Yeah, good morning, everyone from Nairobi. We take the opportunity to welcome you to the second day of the African Regional Summit on global perspectives on corporate climate legal tactics. And I think we had a slide each on the program, as you will notice. We had expected to start with a keynote address from Professor Owino. We will try to get him. He's not been able to join the call. We'll try to get him later in the day. What we're going to do is we're just going to start with the first panel, which is the high-level panel for reimagining corporate climate litigation in Africa. And to the questions that arise, I have three wonderful ladies in the room. I have Iga on my extreme right. We have Emmaqulate in the middle and Elizabeth. So I thought the way we will do it is I will give you a brief introduction to our panelists. And so let me start in that order from Iga, right and the other at the extreme right hand. So Iga Józefiak is a climate science and policy expert. She works for Ernst & Young. She works as a consultant in climate change and sustainability services in Geneva, Switzerland. She is presently pursuing a PhD on policy, on the science policy nexus, in as far as the climate change regime is concerned. She is particularly pursuing case studies of developing countries. And so in the scheme of that research, she has also been able, in terms of her research and her work, she has worked as an advisor for governments and NGOs in as far as climate change adaptation policies are concerned. She has published widely in areas of climate science, sustainability, and climate change law. Iga is also a co-founder of Hydra-Sans Foundation, which is Poland, and it works in reinforcing cooperation between scientists and, from different backgrounds. And so, Iga, it's a pleasure to have you here. Thank you for traveling all the way from Geneva.
Thank you so much.
To come and join the forum in Nairobi. And then next, I think, is Emma, who is the patents, and I think we'll be able to do a few things together. So Emmaqulate is a member of climate justice professional. He is an advocate of the High Court of Kenya. He is presently pursuing a master's in environmental law. She has passion in areas of business and human rights, environmental justice, climate change, and energy transition. She has had significant working experience in areas of policy, advocacy, public campaigns, and she has worked with grassroots communities and also with international actors. She is the founder of the Climate Change Café, which of course is established here in Nairobi. And as well as a Pan-African platform on a mission to enhance lawyers' role in utilizing the law for justice and just climate action in Africa. And so she does this through by encouraging dialogue, learning, and mentorship. She has previously worked in the practice as an advocate. The natural justice and campaigns and advocacy at the Kenya Civil Society Platform on Oil and Gas. She is presently the Global Campaign Action Aid International work to implement the Federation's Climate Justice Campaign. And then we will go to Elizabeth. Last but not least, I think it is important to have prior information on the background of our panelists so that it helps even in the questions that we pose. So Elizabeth is the chairperson of the East African Wildlife Society and also the managing partner of Green Brief, OGO-LAW Advocates, which is established here in Nairobi. She's also a director of the Riara Center for Legal Research and Innovation. She's presently pursuing her PhD at the University of Nairobi Faculty of Law. She has a strong bias towards climate change and wildlife conservation. Interest in governance policies. She's a teacher of law. She's passionate about environmental law, policy and mentoring. With that, not very short introduction, I do wish to welcome you to our panel. And I will try to start things up a bit, so I will not start with Iga. But I will start with Elizabeth, who is right next to me. So our focus today is reimagining corporate climate change litigation. And perhaps why do we need to reimagine corporate climate change litigation? Suppose that corporate climate change litigation is evolving. And the scheme of that evolution, we need to keep on innovating. We need to keep on finding avenues, to keep on pushing the frontiers in order to benefit the most affected individuals. And of course, that's a quest for climate justice ultimately. Corporate climate litigation becomes a pathway to realize climate justice. And so from Elizabeth, we will be interested to hear how human rights are being integrated into climate litigation.
There we go. Thank you, Dr. Omondi, for that introduction and for the opportunity to be in this panel with these good minds. And yesterday as well, we left the conference and we had sleepless nights because there were some questions that were posed that have potential to impact what the future of climate litigation looks like. I think from a perspective of human rights and climate litigation, there's obviously quite a number of cases that we've seen internationally from the perspective of incorporating human rights. We know of the gender case, we are aware of the Juliana case in the US as well. But perhaps one of the questions that arise when one starts thinking about human rights and climate litigation is this evolving area of the rights of nature versus the rights for nature, and looking at certain jurisdictions that have successfully, given identity, distinct legal identity to ecosystems and attempted to protect those ecosystems from the perspective of, centric sort of perspective. And I think perhaps it is time, as we are imagining this climate litigation, obviously there is a huge cost to human life when we talk about climate litigation. And we do have precedents around the issues to do with rights to water, rights to life, right, and this when litigating. Perhaps the additional question is to ask whether the world is ready to move the New Zealand way in assigning rights of nature and protecting and litigating climate issues from that perspective, that this particular ecosystem has its rights in and of itself inherently as opposed to its utility to mankind. And perhaps that might be the next, one of the next frontiers of climate litigation, as I see.
Yeah, I think that sheds light on a very interesting perspective. Rights of nature as contradistinct with rights for nature. And that, in my mind, I think paints still the divide, the common divide between an anthropocentric approach and the ecocentric approach, which I think is a discussion that we can extend to very many facets of environmental law, and of course climate change is no exception. Now, Emmaqulate, one of the things that we really cannot do away with is the place of science, because it is the science that tells the policymakers what to do. What should be the yardstick? What should be the threshold by which we should perhaps reduce our emissions in order to stay within the carbon budget, for example? So what would be the place of science in as far as climate change litigation is concerned?
Thank you, Daktari. I will pass this to.
Yes, thank you. Thank you so much for this question. Distinguished panelists, dear organizers, thank you so much. I'm really delighted to be here and to share my thoughts on science. So when it comes to climate science and climate change, there is a scientific consensus with regards to the state of current climate. The latest IPCC report left us with no doubts that by the end of this century, we can reach as much as 2.8 degrees Celsius global warming. We know also from this IPCC report that the nationally determined contributions are not enough under the Paris Agreement to really stop this warming. We are witnessing all around the world the different impacts like hurricanes, floods, fires. All this is very clear, and the science also is clear about the methods with which we should combat this change. The latest IPCC report stated that outside the formal climate policy processes, climate litigation is another important arena for various actors to confront and interact over how climate change should be governed. That is very novel. Imagine that the IPCC, which is the intergovernmental power, is telling us that climate change litigation is now the way to move forward. That is something very novel, which is showing how important this climate litigation is becoming. So when it comes to the real role of science in the climate change litigation, I would distinguish three main aspects. First of all, for litigation to really be relevant and effective, it needs to be based on science. Like we need to have the scientific grounds to say that, for example, a harm to climate or to environment or to people has been caused. And for this, we need to ensure that thoroughly monitored, that we have enough data, that this data is scientifically sound. So that is the first aspect. Second aspect is that what American scientist once said, his name is Glenn Seaborg, and he said that educating people with science is more important than the research itself. And I find it very relevant here because, especially in Africa, we need to make sure that people are properly informed about the climate crisis, about its consequences, about who is to blame, also which sort of compensation is fair and just without this knowledge, without this education, people won't be able to really claim their rights. And then the final aspect is that science should really constitute grounds for the regulations, for the policies, and because of this, it will constitute an incentive for corporations to fulfill their obligations and to simply do better. We observe this increasing trend of new regulations based on science, like the TCFD or the science-based targets initiatives. So in this private sector, it's becoming more and more a new trend, but yeah, we have to keep this momentum.
Thank you, Igor. I think one of the things we were very deliberate about when we were putting together this summit was to try and bring on board not only lawyers, of course the majority are lawyers, but we had a number of scientists. I think we were supposed to take part. We had Dr. James Kemunto, who is an attribution scientist. We had Dr. Philip Omondi, who is another attribution scientist. And of course, we did have Dr. Emmaqulate, who is an economist, but also a social scientist in a sense. And this is because, I mean, it has been said, in climate change, there are no experts. It's nature as a wicked problem, means that you need all hands on deck. You need to have a constellation of multi and transdisciplinary actors. So now, apart from inviting these individuals, and this is a follow-up to Igor, what would be the best way to involve this scientists in climate change mitigation, because they do not understand the language we lawyers speak. So they're going to be a Tower of Babel of sorts.
Thank you. Thanks for this follow-up question. That is very, very relevant because we all know that we should integrate them better, but how to do it? It's true that this relationship between scientists and policymakers is very vague and very difficult because scientists and policymakers have different backgrounds, they have different methodologies, different ways of understanding, of thinking, and also often different priorities. And how could we integrate? One aspect is, as you said, by creating those platforms of exchange, like conferences, webinars, meetings, where we should include scientists. And here it's important, as you mentioned, not only scientists dealing with climate, with hardcore science, but social scientists, anthropologists, economists, even indigenous knowledge scientists. This is also science, and that should be stressed. Secondly, I think through really enhancing this cooperation between NGOs or law firms that file litigation cases and research institutes, banks, universities. I think this is something that should be strengthened. And thirdly, by also creating scientific appellate bodies close to government or ministries. These bodies would need to be comprised of scientists who would monitor what's going on in terms of science within the national jurisdiction, for example, to monitor what's going on if the environment is polluted, what are the corporations doing, and for this we need really special agencies, special bodies.
Yeah, thank you, Igor. Yeah, feel free.
One of the things, when Igor was speaking about bridging the gap between the science knowledge, the science peak, if I can call it that. I was in a workshop some time back, and we were discussing the 2-degree increase.
Mm-hmm.
And one of the participants said, but what's so wrong with 2 degrees? If you're moving from 30 to 32 at a personal level, and they actually say, let's reduce the AC by 2 degrees and see what happens and increase it. And you can see the disconnect, in that, and perhaps, like you say, there's really there's critical need for bridging that gap. And I was thinking, Dr. for example, from a Kenyan jurisdiction,
And is that a knowledge gap, or how would you describe the gap?
I think that is a communication. It's a communication and jurisdiction. Every time new technocrats in every election cycle, the guys who get elected or get into office have to undergo a mandatory course. In Kenya, it's called Omondi. Yeah. They have to undergo a mandatory governance course, and perhaps maybe that's something we need to think about introducing, especially from the developing world, where any technocrats, any political appointees who get into this, government offices that have huge impacts in decision making, cabinet secretaries, principal secretaries, they must undergo, probably a mandatory climate science sort of workshop or training to understand that, so they can better.
Yeah, thank you for that, Father. Now let me come back to Emma. I saw how uncomfortable she was when I asked the wrong question to the right parents. Lawyers are not inclined to science. But now, what does the future look like when we talk about climate change mitigation? In 20 years, we are imagining, what do you think the future will look like in 20 years?
Thank you, Doc, for that question. I'm excited for the prospects of the future. It can only get brighter because now we are seeing a sort of an uprising of climate litigation cases, be it they started from maybe the global north countries, but we are seeing that even broaden, initially from focusing on governments to now focusing on corporates, and from like the obvious, the carbon ledger corporates, the oil and gas companies, to now corporate actors that ideally you would not think of them as having an active role to play in climate change, but now they're being held accountable. And a good example of this is financial institutions, insurance companies, I'm talking pension funds. So really, and it can only get bigger because what litigation does, as much as it's to ensure that remedies are given in areas where there has been a violation of a right, but it also largely, especially climate change litigation, is largely to make a statement, to make noise, to draw public attention, and to bridge or sort of address this gap that's non-existent in existing laws. And this means jurisprudence will keep growing, companies will keep being held accountable, and because litigation is a huge risk in the corporate world, then I think it's going to encourage that sort of proactiveness from the private sector and from the corporate world to, meet the climate goals.
Yeah, thank you. I think that ties in very well with what we discussed yesterday in the high-level panel 1 on courses of action. And one of the points of consensus was that absence of communication then means a lot of people who would be liable then just go scot-free. And of course, then one of the issues that the panelists raised was that the Climate Change Act has largely been ineffective because the regulations required have never been enacted. And that means we have a framework that has not been implemented. And so, picking from that, assuming then that we are able to implement this act at its best, Elizabeth, what would liability of directors, liability for companies, personal liability, what would it look like? It's best.
I personally think that using personal liability is a huge deterrent factor.
And maybe then you demystify then how this liability attaches for us when we talk of personal liability. Perhaps elaborate on how it attaches and what then would be its contours.
So because we're discussing corporate liability, it's very easy, especially with jurisprudence and case law and so on and so forth, to say a case against ExxonMobil or so and so and so on forth. But we all know that even as we assign names and corporate identity to these organizations, at the end of the day, there are actual human hearts and hands and minds in boardrooms making decisions, in rooms signing papers and making these particular decisions. And as long as we, as a world, are comfortable with people being able to hide behind the corporate veil, then it will be very easy for us to get into a situation where it is, like my panelist is talking about, you just equate it to an insurance premium. And you say, this is a cost of doing business, let's pay the insurance premium. If we get sued, we're gonna pay it as a corporation. But then it doesn't really translate to personal responsibility for the people who actually make the specific decisions. I was seeing a very interesting question by I think it's the current ICC prosecutor about 2 days ago, asking whether if we were to write the statute today, would ecocide?
That should be Karim Khan.
Yes. Would ecocide be a crime against humanity as it is today? And perhaps the question is, would climate change related damage be assigned personal responsibility? So from a personal responsibility and liability perspective, I think it's a really good tool to make sure that when these decisions are made, there is clarity of thought that the decisions people are making in whatever situations, they're not able to hide behind insurance premiums, they're not able to hide behind the corporate veil. Number two, I think also assigning criminal liability. In yesterday's, I think it was the first panel in the morning where Senior Maloa was talking about the different standards of proof, whether it's beyond reasonable doubt, so on and so forth. And perhaps it's time to rethink how we can bring in criminal liability to this. And I was telling one of the fellow participants here, if we were to pull a thread and to reimagine, if we were to get crazy about it.
Swing the pendulum to its extreme.
Yes.
Let's hear what that will mean.
Of being described as thinking quite literally, not only out of the box, but all of the room.
Okay.
We have an offense, a criminal offense, known as causing bodily harm.
Yes.
Right?
Yes.
With very stringent personal criminal liability and penalties. And I think every jurisdiction has this, whatever it is.
Causing grievous bodily harm.
Yeah, causing grievous bodily harm.
Yes.
Every single jurisdiction has it, whatever it is that they call it. Now, someone who is a participant and an active participant in climate damage that has that causes real physical damage to human beings, why wouldn't such a section in criminal law apply to them? Because then, if we're saying that so-and-so made this particular decision and it led to actual grievous bodily harm, because the standard, one of the ingredients does not require that you use your actual hands to physically harm another person, is whether you do or omit to do a thing that consequently, causes grievous bodily harm. So I think perhaps we need to explore a little bit more the place of criminal liability and thus personal liability, because then it will remove the impact gap in the decision-making process. And it will bring the consequences closer home, to allow me to use the word perpetrators at this point. Yeah.
Yeah, that's very innovative. It actually takes me to my first year legal systems and methods class, where we look at rules of statutory interpretation. And so I look at applying the golden rule of statutory interpretation to interpret the penal code to give meaning, to substitute natural persons with the environment as a potential target of harm. That would be very interesting. I would really want to see what judges would say if that argument was made.
At the risk of going against what Senior Malo was talking about, was it you who said that we should not use our cases to set precedents? We should not use our clients to set precedents.
Yeah, but I also understand you to be saying, let us not leave liability at the corporate level. Because yes, we know that a company is a juristic person, but behind that juristic person, there are actors. So that let us attach personal liability by including directors in their personal capacity as actors of companies. That is what I hear you say. Other than have a monolithic entity known as a corporate entity. And so what they simply need to do is put shillings and cents together to pay up the cost of the increased cost of doing business, so that your approach to liability would make it very tight, and you cannot pass on climate change damage under the price of fines and so on. But perhaps, maybe let me shift gears a bit here. Yeah, by all means.
Thank you. Because Elizabeth, it's inspired me to the thought that when it comes to the environmental damage, it's a bit easier with the attribution of a loss to a certain activity, and when it comes to the climate change, it's very hard to attribute that the particular emissions of this particular company has caused, for example, a hurricane which came and devastated houses and caused numerous economic losses or health losses to a country, because often the harm is caused in one place, and then because of this transboundary harm caused by climate change, the effects can be seen in another part of the world even. So I think that is something to think about on how would we attribute these climate change losses.
I think that is already happening. That's already happening. If you look at the case of Luya versus RAA, where you say, okay, it is agreed that the responsibility of the German utility company is 0.47%. So yes, climate change is diffuse and it has a long causal chain, but please pay me to the extent of your responsibility. So I think that is still happening. But let me have your thoughts, Elizabeth. You were coming in just when I...
Oh, no, I wanted to actually bring the other perspective, that outside of corporate litigation, when litigation is against governments and the decisions that governments make, then it might be an easier link in terms of attribution from government decisions and policies and legislative decisions as well. And I think over and above that, perhaps as we're concluding, the personal nature and the sort of lifting of the veil is what is the most important to use as a deterrent mechanism, and not so much as a mechanism to access compensation. So it's quite, because once someone knows that over and above my company being sued, then I will be held personally liable. It sort of introduces a stopgap measure for people to reconsider some decisions and some ways of thinking.
Yeah, but I also think then this concern ties up very well with what we have increasingly seen. I think now, even if you look at Nairobi, for example, I think we already at the Nairobi Stock Exchange, we have certain guidelines on disclosures. And I think we need to disclose then with perhaps resulting in this personal liability that we're talking about. But maybe as somebody who has first-hand experience, what would these disclosures look like in a practical sense? Somebody said the problem with academics is they take something that works in practice and investigate whether it can work in theory. So we don't want to be theoricists. So at Anderson Young, really, what would these disclosures look like?
Yes, I love this. Exactly. So me coming from the academic world and into the private sector, that was a big change. Certainly, we have been observing this increase of the interest of private sector in really enhancing their sustainability actions, aiming for net zero strategies, decarbonizing. It's really a trend that we see not only in Europe, but all around the world, including Africa, especially that a lot of entities with which we work in Switzerland have also their sub-entities, for example, in Nigeria. And all those regulations are becoming more and more binding for the time being. Some of them are voluntary still, some of them are already becoming sort of hard law. Well, I think the trend began to really be evident in the international community at COP26 in Glasgow, where we could really see that private sector started to take with this Glasgow Financial Alliance for Net Zero, with all those initiatives for financial institutions that became really a hype, I could say. However, often with all those regulations and all this interest, there comes the two worrying trends. One is the greenwashing, and another one is the fact that corporations are still afraid of being transparent, of disclosing. For marketing reasons, they don't want to lose their clients. They're afraid that if they're too transparent about certain of their activities, it wouldn't do any good for them. And in that, corporate climate litigation really has the potential to reinforce this good trend, this increased interest in complying with regulations, because it works as an incentive for the corporation. I think that this growing trend of litigation that we see currently all over will really force corporations to start complying more, to be interested in joining more of those initiatives, regulations. I see that it is becoming a new trend, new fashion even, to be sustainable. And of course, yet we still have this phenomenon of greenwashing sometimes, but I still believe and see that more and more corporations are becoming interested in really being sustainable, because they see that it's not only profitable for climate, for environment, for people, but it's also profitable for themselves, for their own operations. So those corporate regulations that we see are something that would be surely increasing all around, but it's still very, very new. And we have to keep in mind that, for example, we still don't have an equivalent of Paris Agreement for private sector. So all those regulations, initiatives are usually, some of them are binding, but most of them are joined voluntarily. There are many of them, not necessarily well aligned one with another. And this is where I see also a potential for Africa. because as we see, the litigation in Africa can be very innovative. Africa is very well, uniquely, I would say, positioned when it comes to its environment, when it comes to biodiversity, when it comes to also tribal communities. So climate litigation coming from Africa is really something that can be innovative and that cannot be observed anywhere else in the world. We cannot have the same cases in Europe as we could file here. And the last point is that also for decades, most of those corporations were fleeing to Africa to do certain of the unsustainable polluting activities. So if we really now start to increase this corporate climate litigation here, there won't be any more way of fleeing, and this will do good not only for the continent here, but for everybody. This will be really beneficial.
Yeah, thank you. I think that really throws the challenge to us, practitioners here, to really take the ball and run with it. Why wouldn't we, for example, go to court tomorrow and sue Total Energies, for example, and look at reports and attribute significant, from those reports, what is the attribution more on the Luya way? But apart from that, we do know for sure, and the argument has been made, and I think I have also made the argument in a paper. But look, if you look at the multinational corporations, and a lot of them carbon majors, then they are responsible for somewhere around 71% of global carbon emissions. But we still organize in terms of states, because we do know that corporations are not parties to the Paris Agreement. Countries are. We do know that corporations do not have NDCs. Countries have NDCs. So what more would these corporations do, Emma, to pick the tab or to carry their fair share of responsibility?
That's a very good question. I wanted to just add on to what my friend here has mentioned around disclosures, and to just maybe throw it out there. There definitely are some challenges that come with voluntary measures, and I have seen, and the growing risk of now climate washing. I have seen cases being brought against companies who have said, we are a sustainable business, but then the loans, the bonds, the money that they're giving out is causing deforestation somewhere in Bolivia, it's causing land grabbing somewhere in Brazil. And so I understand the Kenyan government, or rather the Central Bank of Kenya, is in the process of drafting some sort of a taxonomy of what it entails to be a sustainable business, or what it entails to be to say that you are a green business. And I believe as much as there's this, self-regulation, the corporate taking a step forward to do this, there is still a role that policy can play and governments can play, and this is where maybe scientists come in place, other experts, human rights experts, to determine exactly what is the threshold for sustainability. And then can it be that when an organization or a company meets a certain percentage of this threshold is when they can honestly say that they are running a sustainable business. So that's a gap there. And to come to your question, Daktari, let me give an example of Shell and the horrendous, unspeakable human rights violations it's caused in the Niger Delta. I don't know if in our lifetime the spills and the impact that has been done there can be reversed. And now, as we speak, Shell has left Nigeria. It sold its business to national companies, and it's left. So no one is doing the cleanup. The communities have been left with the mess that has happened there for over 20 years. So one way I can say that maybe litigation only might not be the answer, is to have litigation, yes, but also with other approaches. So other approaches meaning cross-border collaboration through public campaigns. We've seen organizations from Nigeria being supported to file cases in Shell's home country. So that's a sort of support. Yes, there is litigation happening, but where litigation can no longer be sustainable or can no longer be effective, what other approaches can we bring in to ensure that these corporates are held accountable? And cross-border advocacy, collaboration between different organizations in different countries, have seen that really come in handy to sort of try and hold these companies accountable.
Yeah, thank you. I think one very important thing that nobody has highlighted, but of course we have the Kenya Green Finance Taxonomy of March 2024. And I think its goal, it is championed by Central Bank and other actors, is to avoid what you call climate washing. And I think this discussion is important because you're moving us a bit from the general lens of greenwashing into climate washing, which would simply be actions that seem to comply with certain requirements or which seem to enhance mitigation of carbon emissions, while in actual fact their effect might be perverse. And I think right now the famous case that I think is on everybody's sleep is the KLM case. I think Cinema mentioned about the sustainable fuel and the hoax that lies therein. But this then will mean that to avoid climate washing and to avoid camouflaging projects, carbon-intensive projects, as climate-friendly projects, then we'll have to take measures such as that proposed in the Green Finance Taxonomy, because a taxonomy is just a classification of what standards or what threshold you need to meet in order to qualify, so that not anything comes in. And I'll now go back to Elizabeth and ask, then what would be the place of disclosure, climate-related risk disclosure, financial and otherwise?
I think building up on what Peter and Emma have highlighted, I think one of the biggest moves that might have sort of more significant impact is investor-led or investor-demanded climate disclosures, climate-related disclosures, because then, you know, is it the one who pays the piper who sings the tune?
Yeah, he who pays the piper calls the tune.
Calls the tune, exactly. And so, if we have a higher responsibility on investors in these companies and perhaps also major shareholders in these companies pushing for more accurate disclosures and more stringent disclosures as a precondition for access to financing and access to debt, for example, from financing institutions, then we might find you know, disclosures that do not are not caught up in the net of greenwashing or climate washing.
Oh, as you speak, something comes into my mind. And this is, I'm sure some of you have heard it, the triple bottom line accounting, as opposed to the traditional financial accounting, now we need to account across the three prongs of people, public, people, planet, and profit. Yeah. And of course, that then kicks the ball right into the net of ESG.
Yes.
So let me just have your thoughts as a general question. What is the place of ESG? Or maybe to verify the question, what is the practical place of ESG? And I deliberately use the word practical because these are the dangers of things that have a lot of attention. Climate change now has everybody focused on it. And because everybody's focused on it, it becomes a fad. Any solution that you come up with risks being a cliche, or it risks being a buzzword. So when we talk about ESG, beyond the good service we pay, what would it in your mind look in a practical sense? So we can start from Iga, now that she's quite this. What would it look like? And then we can come to the other side.
Thank you. Thanks for this excellent question. Yeah, we moved yesterday. I talked to Ivana that we moved from CSR now to ESG, and how does it translate into practice? It's true that that these concepts, if they are not used in a constructive, organized, structured way, they just are left as a vague concept. But I really see that this ESG, environment, social governance, is having an increasingly important role for corporations. I have most experience with financial institutions, banks, insurers. They really try to follow this ESG concept because some of them are left with no other choice. They are already in place of regulations, or they know that in the next couple of years they will be, or they see that our peers are doing it, so we have to do it as well. So that is the first practical way of how the ESG is becoming increasingly popular. A second thing that is important about this concept is that it touches upon all the three: environment, social, and governance. So it's really allowing us to move to progress, not only in terms of climate change or in terms of GHG emissions, but also in terms of impacts on people, also in terms of how we structure the corporations. So in practice, it also allows the corporations to be more sustainable in general, because every aspect is progressing at the same time. And for that, we are having on this practical manner more and more regulations that are just forcing private sector to comply with this all these various ESG aspects, and then we have companies like EY, which are auditing their operations, which are advising on how to move forward, what to do next, and I think that's the way to do it.
Okay, thank you.
So my take on this, in addition to what she's mentioned, it's definitely a very useful tool, compliance tool. I mean, in most of the time, the corporate space is ahead of policy, ahead of regulation, and it's a way to, ask policy and regulation to catch up. But one, my caution would be, it's a very useful, it's a very important tool that should not be left at the mercy of self-regulation, because then who is holding, where is the accountability, right? And just to add on this is maybe the role that, talking about multinational corporations and accountability, the role that a UN binding treaty on business and human rights would have, the role that business and human rights frameworks in different countries. I know we have a national action plan in Kenya. What role could that play? We recently had the EU Parliament ratify the directive on corporate accountability, corporate responsibility. So how are we then using all these sort of more binding looking tools to drive the role of ESG in climate, sort of in just climate action?
Okay, thank you.
I think for me, when I think about ESG, think about it from a accounting perspective. Where does it sit in the books? The money spent. Does it
Bottom line?
Yes. So does it sit when company X spends money to implement ESG activities or frameworks and comply? Does it sit as an expense from the company, or does it sit as an investment and therefore an asset in the company? Because that framing will impact the decision making of the board when cutting costs or pushing investments, right? So if management is thinking about ESG from an expenditure perspective, then when things get tough, it will be one of the first things to get thrown off, right? So anything that they're doing in respect to social, to governance, to environmental will get thrown off. But if we're thinking about it as an investment and as an asset in the company and investing in, I don't know, biodiversity credits, in climate positive, activities and so on and so forth, and recognized as an asset, then that also sort of changes and influences the thinking and the direction of the company from a strategic perspective.
Yeah, I think that's a very interesting question. And I say interesting because you are likely to answer it depending on where you stand or sit. So that a corporation at first blush is likely to construe it as an expense. Okay? And somebody who is an environmental activist will construe it as an investment. For these reasons, I think there's research that shows that companies that are environmentally sensitive and companies that have taken measures in order to shrink their carbon footprint tend to be attractive to investors and tend to be attractive to shareholders, with a correlative benefit in their profits. But also, this is something that we have not been doing. It is something you now require us to add to our growing list of expenses. And that's why I said at first blush, then it would look like an expense and an inconvenience. And I think that is what then would lead to greenwashing. Because if we thought about climate washing, then what would be the motivation? One of the things I teach my environmental law students, I usually talk to them about externalities and internalizing externalities. And this is where the cost of production is externalized or is relegated to the public. And why do we relegate that cost to the public? Because carrying that cost without sharing it to the public means you're going to incur more expenses. So if we have a coal plant that is emitting to the public without cleaning out the emissions, that makes a big difference because the cost of installing scrubbers to make sure that by the time the emissions are released, that those emissions are inert is quite significant. Or even an aluminium smelting plant. The use of maybe an open fire and the use of a gas for smelting would have a significant cost implication. And therefore, at the end of the day, I think when we talk of ESG, then it means you need to embrace practices that will, that capital outlay project will. So I think there is no clear answer, but that will depend on the cost-benefit analysis that. But really, for me, the answer would lie in then having a legal requirement, so that it's not a matter of choice, but rather a matter of strict liability, and that would now push companies towards there's no choice in this matter, and we either close down or we comply. The other general question perhaps that I would want to float, and this is not a question I would float to non-lawyers, for the reason that we have a paradigm of law, and the paradigm of law has been international law in as far as states are concerned. I tell my students that the old name for international law is the law of nations, because it was supposed to regulate the relationship between nations. And looking at that paradigm is now being questioned, because the same nations now need to cooperate more than ever in order to address transboundary environmental challenges and the classical transboundary environmental challenges, climate change. Let me shift that a bit and come into the nation and look at what you call lifting the veil, lifting the corporate veil. We do know that that is an area of law that is resident under the company law. But now we want to green company law. We now want to green international law. So then how will bring the responsibility of actors, corporate actors internationally, change the law? Because now I have argued elsewhere that international law is ill-suited to deal with corporations, which are the most notorious, to use your words, perpetrators. So how will the need to address climate change within the law change the general terrain of law as we know it? There's some thoughts. So maybe Elizabeth, I start from this end.
I think it's quite an interesting conversation to have that you just introduced. And when you think about the evolution of negotiations and for these international conventions and the conference of the parties and so on and so forth, and the point at which we opened up the opportunity for corporations and NGOs to be observers and so on and so forth, and to have side events, that sometimes become the star of the show more than the actual conference of the parties, right? I think from that perspective, it's a double-edged sword. From one perspective, it would be possible to argue, or plausible to argue, that governments are funded by private sector, right from taxation, but even before you go to the more clean aspects of the funding, to PAC committees, right?
Yes.
Of appointing presidents and so on and so forth, and who is funding with the power. And this money comes from private sector more often than not. So potentially the attempt to completely divorce corporations and the private sector from the malleability of international law and the building of consensus becomes a little bit difficult from that perspective, right? So from that perspective, there's that. From the other perspective, it is possible to argue that, and I think this comment was also made yesterday, that yes, we have international law, and we have international environmental law, international climate change law, but the actual people that it impacts are private citizens and private corporations. So in as much as government is going on to talk about nationally determined contributions, that conversation has still to start from private sector, and certain policies and pieces of legislation that's going to influence private sector. So from that perspective, as a thinker in the space and a practitioner in the space, I advocate for a lot more an increased presence of private sector in these conversations, as opposed to a purely private sector and NGO, actually, and international non-governmental organizations. Be as it may that everyone has an agenda.
Absolutely.
I don't, even Mother Teresa had an agenda. She wanted to get to heaven. Absolutely. At the end of it, with helping people and so on and so forth. So it is possible to manage their agendas and how they over-influence the outcome of international law development, especially in this area. But I also think that using the carrot more than the stick in regulation might offer us a better chance of survival and a better chance of arriving at the goals that we essentially have.
Absolutely, I think that is a fundamental difference, because in environmental lawmaking, you use more carrots and less sticks. Why are you unable to comply? How can we help you comply? Instead of saying, if you don't comply, we will bomb you out of existence. So that is a critical, I think, point.
We don't want to highlight the formers of the equations.
Yes.
Yeah.
Okay. Emma?
Yeah, a very interesting conversation. I do not have a single answer to that. Corporates have and will continue to play a very huge role, although sometimes it's not visible in international lawmaking. We now have negotiations happening on the plastic treaty, and we see which corporates are behind that. The power of corporate lobbying is huge. It's huge, really, than the government sitting there as a representative of, say, Kenya. Sort of like the people who pull the strings behind the scenes, sometimes not so behind the scenes. So it's difficult to divorce the two. It's not possible. But also, something I personally do struggle with, and I know it's absolutely necessary, is how do we make corporates allies? Because something she mentioned earlier, behind the corporate veil are human beings. They have kids, they have relatives, they have, different stories. And sometimes reaching to the people behind the corporate veil, beyond the liability aspect, will also be a way of sort of negotiating change from the inside, which does happen. There are corporates who are genuinely, how can we make the world a better place? So there is that space, but divorcing the two, it's going to be, I don't think it's possible. So it has to be, how do we creatively find a way of working with the two? And again, beyond litigation, what other approaches can we use? Which other actors can we bring into the conversation, so that litigation and law is just one of the tools, but there are also other approaches and other actors that we are having in the conversation.
Okay, thank you. Over to you.
Yeah, thank you. To respond to your question,
You're multifaceted. You're a scientist, but also a lawyer.
Both because of the climate change law. Yeah, to respond to your question, I would like to come back in time with the history. When we started, when the climate change regime was born, and the United Nations Framework Convention.
Let me just arrest the question. When was it born?
Yeah, exactly. I mean, what I'm talking about is the adoption of the UNFCCC in 1992. That's what I would say. Of course, we can say that it's been slightly emerging a few years earlier, but let's assume for the time being that it's 1992.
Yeah.
And it was right after the Cold War. And around the world, we had a really favorable wind for multilateralism, for bringing together all the nations, doing something together. Now we are 30 years later, and we are facing a huge crisis of multilateralism all over the planet, with many nationalist movements in many countries. And this is also visible in the climate change regime. That's why maybe in the last years, in the last COPs, after Paris, we have seen the engagement of multiple different stakeholders, including the private sector. And I think that we, as much as we like it or not, we are not able to change how currently the states are cooperating or not. But I think maybe this is actually an opportunity to do things differently in the climate change regime, to really leave more space for private sector. There are more and more of those initiatives, as I mentioned earlier, the Glasgow Alliance. The thing is that what we should do is to try to maybe more standardize them. Because currently we have bits and pieces, different initiatives, the principles of responsible business, Glasgow Alliance, other small initiatives all around, but we don't have anything international, like an international, private international law that would be really setting some standards and framework for corporations all around the world. And I think that would be something interesting.
Yeah, that has been a significant gap, because in exploring direct liability for corporate actors international law, then you realize that there is no framework. Even where there is a framework governing maybe an organization like the UN, then you find that it doesn't work perfectly. And so I think the best way to close the panel would be to fall back on this person who said that the illiterate of the 21st century will be those who cannot learn and learn and learn. Because what that means is we have to sort of be dynamic, create new knowledge, but also let go of old knowledge and address new problems using new perspectives in order to develop new solutions. And that dynamicism is not something that comes automatically, because inherently the human mind is resistant to change. I think I will now open the floor. I'm not able to see our online audience, so perhaps I don't know if there are any questions on the chat, but also on the floor. We could now Mark, if you have questions. If you have questions, the panelists, I think Mark has a question, so let's extend the microphone to him.
Thank you very much. I really enjoyed listening to all the insights. I had two questions. One is on the issue of science-led policy making, which I think is really fundamental. I think, do you see a potential role for practitioners to push more of that? And also using that as a lens, perhaps to even evaluate when proposals are made for regulations around our climate change act and policies. Secondly, you also mentioned the need for data. Is that something also we as practitioners should be thinking about pushing for? And if so, what kind of data should we be asking for to help inform better making and decision making? Where does that obligation fall? I'm assuming here it would be the state. And then the second is around, and I think Emma mentioned it, also thinking around making corporates allies. And I'll tie it to what I think was mentioned yesterday. We still don't have corporate obligations do we see a place perhaps in pushing for corporate guidelines, voluntary ones, that our key sectors come up with collaboratively with their different stakeholders to start perhaps even inform of sort of binding obligations later on. And then I think maybe a final one is on the question of business and human rights, and I think this question of the utility of international law. We have business and human rights guidelines at an international level. Should we be pushing for binding business and human rights obligations at a national level? The action plan as a starting point, is it sufficient? Do you see that it might be helpful even in informing and shaping climate litigation, or is there need for us to push for something stronger, even as we wait for climate change?
Thank you so much for your questions. Let me start with the first one about the practitioners and science. Definitely, I think that currently there's a need that practitioners push to include scientists in their practice. And here I mean all sorts of different scientists, depending also on the case. But you know, all the different sciences are relevant, whether it's social science, political science, environmental science, economics. All these can really constitute a big value, and which can also just facilitate your work because of this cooperative teamwork. I think that the greatest result can be achieved by that. I see a growing trend. Slowly, states are really including in their teams of lawyers one or two scientists as a subject matter expert who can advise or issue a report that would be constitute a ground for their cases. So that is something I hope to see more and more, because I really believe that lawyers not necessarily have all the knowledge to justify some of those claims, and having really scientists which give the real voice of what's happening, that can be really important. And it's seen more and more all around. When it comes to data, your second question, what kind of data? Well, absolutely any sort of data and monitoring is important currently. What I meant in my presentation was to really create some scientific bodies that would be responsible for data collection within countries. But then the system of data sharing between internationally would also be something to have in mind. What is also important in that science lawyers, science policy makers cooperation is to translate the data into pragmatic language, understandable language, because scientists which analyze certain environmentally related data don't necessarily operate the same language as practitioners. And then practitioners, when they will receive this data, they will see that, okay, certain amount of GHGs emissions was emitted. What does it mean? Is it a lot or is it not? What Elizabeth mentioned before, the 2 degrees, like it's just 2 degrees. So that is something also to develop, to really try to find interdisciplinary methods and interdisciplinary understanding of certain concepts so that we could understand each other more. Yeah, should I give you the floor to answer or should I continue with the alliance? Okay, I can continue about your third questions of the corporate allies. I think what's important is indeed to push for some internationally set corporate standards or framework that would guide corporations all around the world, and that would make sure that we are all on the same page and that we are moving forward at more or less the same pace. This is already happening more and more. For example, EU has its own framework, or there are those voluntary initiatives like the Glasgow Financial Alliance, which is comprised, I think, of like 650 corporations all around the world. So these are huge initiatives, but still we don't have anything really international that would apply to all. But I think it's a big challenge also to create something like that, given all the different perspectives, all the different interests, all the different problems and that we are facing in different continents. But yeah, in the next years, hopefully we will be able to agree on something like
that. Maybe just to add on to what she's mentioned. So, yeah, these are very interesting and difficult conversations, but international, like sort of an international, I mean, the negotiations happening around the UN Binding Treaty on Business and Human Rights. I'd be very curious to see the outcome of that, and it will have been such a missed opportunity if climate change does not, the climate change language does not find its way or make its way to the text of the treaty, but also just in the nature of international law, it's very, you have to make a lot of accommodations to get a binding treaty, or have more stringent recommendations and not have a binding treaty. So it's a very shaky kind of tool to place our hopes on. But at the same time, I feel like there is an opportunity to strengthen the national aspects of what's already happening. For example, you asked about the National Action Plan that we have in Kenya on business and human rights. I mean, it's complemented very well with by the Constitution of Kenya, which has an horizontal application of human rights, that businesses can be duty bearers in human rights conversations. And we then move on to the Environmental Management and Conservation Act and many other national laws that would essentially cushion or rather give more weight to the National Action Plan. I don't know if what we need is more laws. I'm not sure because we are having a difficult time implementing the ones that we have. The Climate Change Act was enacted in 2016. It's about, sorry, I feel like
8 years?
Yes. Yes. We don't have like regulations yet, certain regulations yet. So that really, and it's not a loss because we have other pockets of the law that we can borrow from to see that the language of the National Action Plan on Business and Human Rights is implemented. So let's test out the courts. I don't know if courts have pronounced themselves yet on that, on the binding nature of that National Action Plan. I know there are cases which have gone to court on international, rather multinational corporations in Kenya and human rights violations. So that would also be a good way to look at. Another maybe final thing to mention around the challenges of having, say, a one binding international standard on climate change or maybe corporate responsibility is also the fragmented nature, because yes, there's the environment space, there's the climate change space, but also there's the trade space, the WTO space, there's a lot of other spaces where we cannot have an overhaul in one area and leave the other and expect that this one area will be successful in its implementation. So it's definitely a conversation to keep having, boundaries to keep pushing, and excited to see how the text of the UN binding treaty on business and human rights will look like.
And just pleasantly disappoint Mark. I think when I was doing my PhD research, one conclusion I came to was that binding instruments are not always more effective than soft law instruments. To the contrary, soft law instruments tend to be more effective because there's a lot of buy-in. And anybody who buys in is likely to do their fair share. But when you want to get people to do things by compulsion, then there's resistance. And that is why I will agree with Emmaqulate when she says, when you are negotiating a international agreement, one of the things I found as a useful tool is vagueness. At times you read the text of a treaty and it is vague. And that vagueness is important in enabling parties to ascribe to that treaty or to consent, because the cornerstone of any binding international instrument is consent. And so how do you get consent? You get consent by watering down certain provisions or toning down certain language in order to accommodate the interests of other people so that it is ultimately participatory. Because when you look at an international framework, you can talk of participation and the stringency. The stringency would relate to how strict are the provisions. And you will find that if an instrument is extremely stringent, then it takes 20 years to ratify. It takes 20 years to sign. When they are less stringent, then there's greater buy-in, like the Paris Agreement, which yes, versus Kyoto, for example. There were 195, and it was ratified in record time. In Kyoto Protocol, people were actually leaving. Canada left. The US ratified, signed but did not ratify, and there was a lot of pull and push. So I think we should also bear that in mind. I don't know whether there were any further questions.
Just add one more thing on the science. Just inspired me for one more thing regarding the science that you asked me and the practitioners. So a month ago, an advisory opinion was issued by the International Tribunal of the Law of the Sea regarding climate change. And that is really a groundbreaking advisory opinion because it unanimously said that greenhouse gases constitute marine pollution. And that is basically a quote from what the scientists have pleaded a year earlier during the pleadings. So it shows that really what scientists say and have to say with that regards matter and is more and more included by courts.
Yeah, okay. I have, I think on the Climate Change Act in Kenya, it provides for fines and terms of imprisonment for directors of corporations that are in breach of the act. It provides for no sanction against the corporation itself. I believe that the provision here is against directors extend to their personal capacity and their personal, but not against the corporation itself. Do you think there's room for improvement of this particular sanctions provided here? That's the first one. That's to include direct impact on the corporation as well as the directors. Second question is basically the way that fines are being provided for. I see it in a lot of Nigerian legislation. When I teach my students, I usually highlight that potential weakness. Fines are provided as a maximum. In other words, here it says that the fine is the maximum of 500 million Kenyan shillings. Yeah, in other words, it sort of ties the hands of judges. So when the environmental or climate impact is huge and massive and goes beyond 500 million Kenyan shillings, the judges can. I usually advise that legislatures should look towards providing for fines as a minimum, like let's say a minimum of 50,000, 100,000 Kenyan shillings, or they are dangerous to that, so that the judges can have enough space to inflict as much fines as fit the particular situation before it. Because when the impact on the environment is massive and grave, respond in that light. But again, I see the potential danger in that. But that's the minimum judgment. I think it's better that way. I would just like to hear your comments. Okay, I think those are next questions.
I think maybe very quickly.
Sorry, as well as imprisonment, it's also provided 10 years. I think so. We put it to
I'll perhaps comment on the last part and maybe let the panelists speak, but I think Elizabeth had talked about liability. Actually, for me, it is better to set a maximum. In countries that are victims of corruption, if you let a judge be a law unto himself, by letting him inflict as much as he wishes, that would be a very dangerous trend. The legislature should look at what really is deterrent. Because if you talk about 500 million Kenyans, oh, that is, just walk around the streets and ask who has that. You'll be lucky to find one person. They wouldn't have it in assets or in what, and just even get a company that can pay 500 million without batting. That would be so few. But then if you give discretion to judges, then you also allow them to legislate. Because every time it's in a state of flux. So I would rather you set a cap, and of course there's usually the provision that cap should be in addition to imprisonment, so that you can read it conjunctively or disjunctively. Now that is the area where maybe the court can exercise discretion. So I think it's quite balanced.
Okay. So just to chip in, one of the reasons why I proposed that, maybe it's due to the fact that Nigerian legislatures, one of the reasons why I proposed that is Nigerian legislators are actually very lazy when it comes to updating the laws. So you can find punishment for certain environmental crimes that are 100 years old, 50 years behind the cost of value, such that, say, for example, the penalty for killing a gorilla in Nigeria is something maybe like 50 Kenyan shillings, which cannot even buy the finger of a gorilla in Nigeria, because it's an old law and it has not been updated. So if the fines were provided as a minimum, judges can take into consideration inflation and stuff like that, and provide for a more appropriate sum.
Okay, I think I'll hand over the mic to Elizabeth or somebody else.
Sure, it's quite an interesting one, but I'm with Dr. on this one in terms of susceptibility to corrupt practices. And it's a real concern because then it becomes a negotiation. The maximum is 50, how much are you willing? You know, that becomes the conversation. Going back to the conversation around corporate liability and the directors. When you read the section of the Climate Change Act, you find that there is an imprisonment term assigned as well. And in our justice system, it's only a criminal court that can gives orders for imprisonment and not a civil court. A civil court would obviously around contempt of court. It's limited to contempt of court in terms of imprisonment. And so that would then fall under the auspices of the Director of Public Prosecutions. And so we haven't seen, at least I haven't, unless my colleagues in the room can correct me, but we have not seen a criminal prosecution, which is why I was saying that it's one of the routes to go, because outside of the penal code, there is actual provisions, at least in our law, that would allow criminal prosecution of directors. directors, but we're still yet to see that. I think the only criminal prosecution we have seen is outside of climate, in the environment spaces, in wildlife, and the trafficking of illegally obtained trophies and so on and so forth. So that's the challenge that we have with sort of enforcing that particular section of them.
I just wanted to promote that because actually earlier this year in France, it was introduced that for failing with the CSRD, the Corporate Sustainability Reporting Directive, there is a jail time of up to 5 years for the directors of the corporations. So that was also a big novelty, but so far only in France.
Yeah.
I will request Ivana to read the message on the chat. I'm not able to see it on my end, so just read it out so that the panelists can take it.
So there is a question in the chat from a question. Are there any innovative ways that Gen Zs or other the upcoming youth be actively engaged in when it comes to climate change litigation? If there is an impact they can make, how exactly can they get involved as there is now?
That was by one boy, I believe.
1 week.
Okay. So I'll throw it to the panelists. Is there a way Gen Z can be actively involved in climate change litigation?
I think Gen Zs are the most courageous generation of our time, at least from a Kenyan and African context. I think the only other people who came close to those forms of courage are the ones who fought for decolonization of the continent. And so I'm a bit sad that I'm a millennial. But from that perspective, I think one of the things from a corporate litigation perspective, I think it was mentioned probably yesterday around intergenerational equity. I think there is potential for Gen Zs or the younger generation to actually institute and become, petitioners or applicants in cases, especially surrounding climate damage, corporate climate damage that is occasioned by corporates, specifically from the lens of intergenerational equity and how that is affecting their capacity as a generation to live to be 100 years old and the quality of life implications of the current decisions that have been made. So off the top of my head, I think that would be a really impactful perspective, especially if they did a class action suit. It would be one of the most marvelous things to watch in our generation, I think.
Yeah, I mean, what a time to be a Gen Z, right? Just to, I'm still drawn back to the bravery that we've all seen in the Kenyan streets in the past 2 days, of the young people coming out to, say, enough is enough, right? And even worldwide, really, the climate movement is fueled by young people. So there's that space, there's that opportunity. Maybe what I would add to what Liza's mentioned is the aspect of mentorship, the aspect of learning. There are spaces that are offering that. So feel free to, immerse yourself in these spaces, learn as much as you can. I did not learn climate change in school. So, so there's really a huge opportunity for, as long as there's the interest, to learn, to ask questions, to reach out to the leaders or the people you see in the space. Because the knowledge itself, as much as you may not go to court to litigate, will enable you to start asking questions, holding your leaders to account.
Okay, thank you very much. I think that's a good note to end. And perhaps to avoid Greta to back with her Friday for Futures should be an inspiration. You can just carve out your space. So thank you very much, dear panelists. the audience in person and online for your attention. And I think now I will hand it over to Dr. Owino to give us the way forward. Because I see Professor Olawi is on call. So I don't know whether we take a break and come back to his presentation, but I think he will let us know. Thank you.